जय जय कृषि परिषद भारत की, सुखद प्रतीक भरत भारत की। कृषिधन पशुधन मानव जीवन, दुग्ध मत्स्य फल सुवर्धन। वैज्ञानिक विधियों श्यामला छवि भारत की। जय जय कृषि परिषद भारत की। हिम प्रदेश से सागर तक, मरुधरती के पूर्वोत्तर तक, हर पथ पर है शक्ति। शिक्षा शोध प्रसार सकल तक, आशा स्वावलंबित भारत की। जय जय कृषि परिषद भारत की। जय जय कृषि परिषद भारत की।
Thank you. Respected Director Sir, Dr. K.H. Singh Saab, Dr. K.H. Dr. Mirnal Kuchalam, and all my fellow colleagues and the administrative staff and technical staff and all other members. And today's speaker, it's indeed a great pleasure to all of us. Today we have a eminent speaker, Professor Dr. Gayur Alam sir, who is a senior professor and of the business laws and IPR, and he's also heading the undergraduate studies. And sir, you welcome on our behalf to you on this occasion. So today we are celebrating the World Intellectual Property Day. Sir, just a brief introduction that WIPO, which is a World Intellectual Property Organization, which is UN-based organization based in Geneva, Switzerland, which was established in 1967 and it came in operation 1970. And this WIPO helps all member states in forming laws and administrative treaties. And currently, WIPO has 193 members, including India. And we joined WIPO in 1975. So the first IP Day was celebrated in 2000, which was main focus on celebrating creating the sustainable solutions. And this activity basically sensitizes the awareness on IP among the people and connect the investors and the creators so that all over the world to bring a sustainable future for all of us. And this year we are celebrating on today, 26th April, the World IP Day, which is the main theme is IP and the Sustainable Development Goal. This goal theme was finalized by WIPO, and this is the basically building our common future and innovation creativity. This theme highlights the importance of IP in achieving the sustainable developmental goals and creating a better future to all of us. As you know, the last year we also celebrated the same IP Day on 26th April. That time the theme was accelerating innovation and creativity, the women and the IP, basically to inspire the women creators and the entrepreneurs for harnessing their potential towards the innovation and creativity. So with these few words, again welcome you all, sir. So before I start, the talk by our guest of honor, the eminent speaker, Professor Gayur Alam sir. So first I would like to say a few about him. That Professor Alam is, as I already told, that he is a senior professor of business laws and IP rights and dean of undergraduate studies at the Institute of National Law University and Institute and Law and University at Bhopal. So he is the head of the Department of IP Rights and Business Law. He is the chairperson of Center of Business and Commercial Laws. He is also chairperson of Center of Science and Technology, and also officiated as a director next to who is the vice chancellor of the NLIU, that is National Law Institute University, and he also officiating the registrar of this prestigious university and on the institute. Dr. Alam has got excellent and meritorious academic record during his school exams and degree accomplishments during his LLB, LLM, and secured second position in the university. He awarded Fulbright Fellowship in 2005 for the part of his doctoral work at the George Washington University, Washington DC, USA, and awarded PhD in law from the National Law Institute University, Bhopal. Dr. Alam is the first and founding faculty of this prestigious institute based in Bhopal. He joined as assistant professor in 1998, and then at that time this NLIU came in exist in the Gazette notification, and since then he is contributing significantly in the development of this setting of this prestigious institute. He has been developed several courses including common law method, law of contract, IP rights, trade and law, sociology of law, constitutional law, administrative law, banking law, legal writing, science technology law, biotechnology, and law, civil procedure, etc. He has also organized many seminars and the conferences related to the law and nuclear technology, law relating to carries of goods, artificial intelligence and patent law, disruptive technology and patent law, and advanced patent law. Dr. Alam also mainly specializes in the use of case method, logic and reasoning, and the methods of learning how to learn and apply law. His area of interest is case method, IP law, and business law. And he also supervised, during his tenure, he has supervised 8 PhD students and more than 40 students for LLM and 10 for the BA and LLB. Professor Alam was awarded one fellowship from WIPO, that is WTO, to attend 16th WTO Colloquium for Teachers of IP at WIPO, Geneva, Switzerland, and also part of the delegate from the Government of India to the Oxford University, UK, 2022. And he also attended several international conferences abroad, and also part of the government deputed delegates to many such meetings abroad, like in USA, UK, Qatar, Geneva, Switzerland, South Korea, etc. Many more. So Dr. Alam has also published many articles in international refereed journals. One such is Monsanto's BT cotton patent, and India Court and Public Policy has been published by WIPO WTO in Geneva in 2019-20. He has also authored one of the research articles, that is COVID-19 pandemic congenial fluidity of proposal for waiver of IP rights and the road ahead. He has been recently also by WIPO and WTO in the special edition of the paper published in the journal in 2022. He has delivered more than 300 invited expert articles and acted keynote speakers on various topics, issues of law and academic programs organized by national and international institutions. He is the editor of NLIU Journal on IP law, editor-in-chief of NLIU Journal of Business Law, and he is a member of advisory board and editorial board of several law journals and law reviews, such as Journal of IP Rights, which is being published by ICAR, New Delhi. He is the member of American Society of International Law, and in the past also he has served the member of Copyright Enforcement Advisory Council of the Government of India, and he is also the member of Subcommittee of Copyright Enforcement Advisory Council of the Government of India. So with these the remarks and his achievements, so we welcome you, sir, and really we are very much highly privileged to be here as one of the eminent speaker on this occasion. So now I would request Professor Alam sir. So the floor is yours. So please enlighten words on the IT and how it can be helped to our community. Thank you very much.
Thank you so much, sir. Thank you, and a very good afternoon to all of you. It's a post-lunch session, and I was told that we cannot schedule this session earlier because that's the lunch time for scientists. So my apologies that if I shortened your lunch time. I also take this opportunity to wish a very happy IP Day to all the creators of knowledge present here. That we have to celebrate creativity, we have to celebrate innovation, we have to celebrate invention, we have to celebrate intellectual property. But first and foremost, what I think that am I audible, or is there any problem at your end, or can you hear me?
Yes, sir. Yes, sir.
Okay. Thank you so much. Thank you so much. So we must celebrate creativity, we must celebrate innovation, we must celebrate invention. At the same time, we must also celebrate and reward, not merely celebrate, but also reward creators, innovators, and inventors. I have shared or sent the PPT to the email address through which I received the invitation, with the hope that the slide may be shared from the end of the host. Sir, have you received my email that I sent today?
Yes, sir. We are sharing. We are sharing the same.
Okay. Thank you. So, celebrating inventors, or sir, please minimize the slide. At least I can see some faces. If I need, we will go to the slide presentation, because I prefer to interact with creators, with innovators, inventors, or anyone in the meet space. But as the things are, it is in hybrid mode, but at least some faces are visible. And for may I request you to please minimize the slides, because I don't want to share the slides at the moment. I want to see the faces of participants.
Sharing close कर देना.
Sharing close कर दें. Because speaking to a screen is difficult for me. And I'll request you that if you have any question or any comment, or you do not agree with me, I'll be very happy if you interject and intervene, because you are scientists, trained as scientists. I'm trained as lawyer. I'm not trained as scientist. Patent law in particular, protection of plant varieties in particular, has an essential, inseparable, indispensable connect with science and technology. So when we are talking about rewarding the creators or rewarding the scientists, may I know that if ICAR or your institution has a policy of sharing the invention with the scientist, or whether the institute will be recognized as the owner of the invention, or the scientist is recognized as the owner of the invention, as per the policy of your institute?
Sir, in ICAR, we have very specific guidelines.
Sir.
The intellectual property shared in the institute as well as in the scientist. So there are guidelines are already there for the.
Those guidelines provides that the invention will belong to.
But they have prepared. There is one intellectual property cell, and they have prepared a document very specifically mentioning that how much proportion of this technology, some amount is earned. So the whole aspects have been given in detail.
That's very good. That's very good. My precise question is that if a scientist succeeds in inventing something during the course of the employment, utilizing the resources of the institute, whether the invention will belong to the institute, to the scientist, or jointly by the scientist and the institute?
See, the IPR shared, but the credit goes to the organization.
Yes, because we have this model. We have this model. So, and please feel free. It is academic discussion. That is it incentivizing enough or rewarding enough for the scientist to invent, or go to their lab, do their routine work, and return to their home? That's one, that if the invention or the ownership of the invention goes to the organization, or ownership goes to the scientist, but here public money is being used. So it may be a better idea if the inventor, if the ownership of the invention is shared by the organization, and the inventor or inventors, as the case may be. So which will be more incentivizing, and which method will be better promoting inventorship in a particular organization? Whether the existing system is good, that is conducive to invention, or what do you think? And if there is any problem, because many times what happens that speaking against the policy of the organization may be problematic, but we are having an academic discussion. But still, you are free to respond to this question or not to respond to it. Okay. Now, I heard the sound of silence. So here, when we talk about agriculture and IP, the topic that is given to me is intellectual property management in agriculture related inventions. Right. We are an agrarian economy, that's a well-known fact. And industry's secondary sector, it is primary sector is agriculture. Services tertiary sector. My hypothesis is that agriculture sector in India particularly has been a Cinderella of intellectual property rights. And in a paper that was referred to in my introduction, and that is also available on the website of World Trade Organization, where I have argued in a paper relating to IPR waiver that there are unwarranted fears relating to patent. So in India, somehow the legal regime is such which is not very encouraging for the scientist. In my opinion, I may be mistaken, and that is why I want to hear from others that whether it is what I am thinking is plausible, correct or not. That is one way. Many inventions relating to agriculture are excluded under Section 3 of the Patents Act. What we think that if patent law or inventions relating to agriculture are patented, though I have identified some inventions relating to agriculture which may be patented, but most of them are not, which are explicitly excluded by the provisions of Section 3 of the Patents Act. If I'm going very fast or very slow, or I'm not audible, or I cannot reach you, please raise your hand and interject that. So let us move to the PPT presentation, and may I request you to share the slide?
Yes. First slide.
Next, please.
Next.
That we have very limited time. The objectives that I have set in for an hour, I do not know that to what extent I'll be able to help you achieve those objectives, but the objective is to equip the participating scientists to understand the relationship of agriculture related inventions and IPR, and how and when to promote creation, protection and management of such inventions through the most appropriate IPR. The second objective is much bigger because it says how and when, right? To promote, there are 3 stages: promote. After promote, there must be a comma that I forgot to put. Promote, create, and protect. Then thereafter management. So there are 4 stages. And what will happen after the session is over? The participants will be able to have a clear understanding of different types of IPR. May I begin with a very simple question that how many types of IPR do we have at the moment? Number, how many types of IPR are there?
11.
From many, in fact, at Agriculture Research Institutes, we have technology like varieties. We are a crop institute, so we develop varieties are used by the farmers, and we have some publications also. They are covered under copyrights, and then some software also we develop, so they are also covered under copyrights. That under design also we have some of the design of farm implements. They are also covered. I think mainly yeah, we do not have, but that is available for some other products. For example, some special variety of rice and some other
Trademarks also.
trademarks. These are the generally we are not industry based institutions, so patents are very limited. Only some of the areas of research, for example, biotechnology, where we apply for the patents. But our main products are covered under protection of plant variety and farmer science. So this is it, the presentation.
Okay, so thank you so much. Thank you so much. Thank you so much. Because scientists, they have their own area of expertise. My question was very simple, and the question was and is that how many types of intellectual property rights are there? There are 8 types of intellectual property rights for the time being. And somebody wants to say something? Somebody wants to say something? If you do not want to say something, please mute your mic, right? Because it appears that as if somebody is interested in saying something. So if you want to say something, please say it. So why I ask this question, that many a times, even in the newspaper like Times of India, Hindustan Times, national dailies, they use the IP terminology wrongly, absolutely mistakenly. That, for example, they may say that what is being protected under trademark, they may say it is patented, or it is so subject matter is entirely different. Please understand, subject matter of patent is an invention, not in the scientific sense of the term, but in the patent law sense of the term. That is very clear. That is very clear. Then we have copyright for expression, which is reified in a tangible medium. Then we have trademark, which is used to distinguish the goods or services of one person from the goods or services of another person. Then we have designs of goods, for example, bottle, car, sari, jewelry, shoes, tie, which appeals to the eyes. So that is known as design. And the name of that right, interestingly, is also copyright. So there are 2 copyrights, one copyright under the Copyright Act, the other type of copyright under the Designs Act, but the subject matter protected by the 2 copyrights are entirely different. They are different. Then we have geographical indications of Goods Act, which deals with the goods to whom or to which certain specific qualities, characteristics, or attributes are attributed because they are either found or made or manufactured in a particular geographical origin. So that is what geographical indication. And then plant variety. In plant variety, we talk about registration. It is plant variety protection, is not patent protection. Please understand that when we go for registration under the Plant Varieties Act, whether we are going for extant varieties, farmers varieties, or new varieties. So we are not going for patent. There is a separate protocol for that. And then we have semiconductor integrated circuit layout design. And then we have trade secret. So there are 7 statutes made by the Parliament occupy dealing with different subject matter, but put together, they are called intellectual property right, trade secret. On that, we do not have a statute or a legislation, but it is also an intellectual property right. So, in all, there are 8. So, purpose is that we must be very clear about the vocabulary that what we are talking about. And then, can we go to the next slide? What I say that agriculture has been Cinderella of intellectual property rights, not a favorite of intellectual property right. Intellectual property right, in a sense, and particularly patent, is closely associated with industrial revolution. So one of the responses to industrial revolution was patent, right? That those who come up with new invention, if you have read the story of Thomas Alva Edison and Westingate, anyone who has read about the history of invention of bulb, use of DC, AC, anyone? Westinghouse and Thomas Alva Edison. Anyway, Thomas Alva Edison was working on DC or direct current, and Westinghouse was working on alternate current. So it was basically industrial revolution to which the patent law was responding. So agriculture was not part of the process because initially the whole family of IP was मुझे सुनाई नहीं दिया आपने क्या कहा?
Please continue.
Please.
There's some noise from outside.
Some noise came from the mobile. Please continue.
Oh, not. I had somebody wanted to say something. अच्छा, मैं एक रिक्वेस्ट करूंगा कि अगर आप लोग आज मुझे सुन ले और ऐसा लगे कि we have to interact, so I'll prefer to interact in the physical mode because it is just a formality. I do not know because I'm not satisfied. During COVID, this was the only mode of interaction. Then it was good, but anyway, let us focus on this. So agriculture was not the focus or favorite of IPR. It was the industry. But in US, what happened that farmers in US, they launched a protest in the first quarter of 20th century from 1910 to 1930. And they argued that IPR regime seeks to promote industry at the cost of agriculture. Here in India, somehow that hasn't happened. That farmers, I have not heard any farmer organization in India arguing in favor of IPR, but there are NGOs and others who are arguing against IPR. So that is where we are. So it's a contest, a problem, and should we be arguing this way or that way? The idea is that what will be most beneficial to the farmers in particular, and what will and the society in general. Whether moving away from IPR protection is beneficial to the farmers or coming under IPR regime is more beneficial to the farming community. In US, however, farmers were successful, and the act known as Plant Patent Act in 1930 was enacted by US Congress. Though the scope of that was limited to a sexually invented plant. If the plants are sexually invented, they cannot be protected under the Plant Patent Act, but a sexually invented plant through grafting, sporting, they were considered to be a patentable subject matter, provided they rise to the dignity of an invention. At the international level, in 1961, though we were not a party to this, we had submitted an application to become a member. In 2019, that application was pending. I do not know what has happened now. Tried to check it, couldn't find the latest information on that. But now India is willing to join this. Maybe that the joining has already been completed, that I am not aware of. But the application has been made by Government of India to become a member of this. So that is the international level. So next slide. Is there any question or comment till what we have discussed so far?
No, sir.
So please continue.
Acha. Indian response in this regard has been rather slow. In the year 2001, we came up with an act, and we took a very long time to bring that act into force. That's another side of the story. There's no doubt that agriculture sector may take advantage of existing IPR regime, but not in the same way as industry can do. And similarly, the scientists working in the area of agriculture cannot take advantage of IPR the same way as the scientists who are working in the secondary sector or in the tertiary sector. So that discriminates the scientist also and also the sector. GI and Plant Varieties Protection Act, these are the two enactments which may be directly used by the agricultural sector. Under the GI, whether it is natural goods, whether it is agricultural goods or it is manufactured goods, provided it satisfies the requirement as prescribed under the GI Act, they may be registered. And then I think that there is a need to bring about a change in the patent law so as to make it more friendly to agriculture sector. And then, though it is assumed that inventions in the field of agriculture have traditionally been and presently is excluded from the patent protection. That is what is one of the assumptions. Next slide. What is excluded? There are three subclauses, clauses under Section 3 of the Patents Act. One is, no method of agriculture or horticulture can be patented in India, even if it is an invented method. Right? It cannot be patented in India. So that is one handicap that we have. Any invention of plant or animal in whole or any part thereof, other than microorganism, cannot be patented. Seeds cannot be patented. Varieties, invented varieties I'm talking about. I'm not talking about traditional seeds. I'm not talking about traditional varieties. I'm not talking about traditional species. And essentially biological processes for the production or propagation of plants and animals. These are excluded. An invention which in effect is traditional knowledge or which is an aggregation or duplication of known properties of traditionally known component or components. इस पे आप लोगों का कोई प्रश्न, कोई कमेंट, कुछ कहना चाहेंगे?
We would like to know, sir, that what kind of agriculture invention is may be protected under patent act.
On this slide, there is no question. तो नेक्स्ट स्लाइड पे चलिए, फिर उस पे जवाब है, आपके सवाल का जवाब इस पे है. A perusal of the above clauses further reveals that the following things in the field of agriculture can be patented. Invented microorganism. For example, you invent a microorganism that increases the yield of any agricultural product, or that eats up, for example, insecticides. A microorganism that eats insecticide, that also eats pest in the crop, and that also improves soil quality, for example. That because if you have read about one microorganism that was invented by an Indian, though he applied for a patent in US and he was working in US also, he invented a microorganism that can eat oil. So that microorganism is used to control oil spill. So if you can invent a microorganism which can boost any agricultural activity, that is one that can be done. And maybe you can invent mechanical, electrical, but please understand here, number two is what? Industrial, directly, right? Because my hypothesis is that the patent law is not friendly to agriculture sector as it is friendly to the industrial sector. So if you come up with some mechanical, electrical, or electronic appliances, that is another area that can be done. But they are more close to industry also, because industries they produce, they may be used. Here, agriculture sector will be a user of that. Only invented chemicals used in agriculture. You can invent some new chemical. Invented medicines based on agricultural products. Invented software program related to agriculture. Inventions based on traditional knowledge, right? These are the 6 areas that I have been able to identify on my own, that these are the things that can be patented, right? That can be patented. And then this is my thinking on this particular, that how agriculture sector and how the scientists working in the field of agriculture may take advantage of patent law, right? So, and there may be more areas that I have not been able to think of. So can any participant think of any other type of invention which is not barred by section 3 that we discussed in the previous slide, and which can still get the patent protection? मैंने 6 सोचे हैं एग्रीकल्चर सेक्टर के लिए. आप लोगों को अगर कुछ लग रहा है कि नहीं ये भी हो सकता है, तो प्लीज रीड सेक्शन 3. जो और may I also request the host that please circulate the PPT to those scientists who are interested to go through the slide. If they are not interested, don't bother them. Next slide, please, unless somebody has to say something.
Sir, I have a question.
Thank you very much, sir. I was waiting for one. Yeah.
Sir, nowadays natural farming is promoted on a big way. So it is also some kind of ITK, the traditional method. But there are certain things that has been added in this method. So can it be patented?
For patenting anything, sir, there are broadly speaking 8 gates that one has to enter one by one. Broadly speaking 8 दरवाजे हैं. जैसे चक्रव्यूह में अभिमन्यु के तो 7 दरवाजे थे, शायद इसमें 8 दरवाजे हैं कि पहले में अगर एंट्री मिल जाएगी तो जरूरी नहीं दूसरे में मिल जाए आपको. So number 1, the question that you have asked is a very, very general question. Right? The invention must be very specific. What is it that in natural farming one has invented. I can give you one example. Sir, have you heard about cinchona tree?
Yes. Dalchini. Dalchini. Yes, yes. Dalchini.
अच्छा, उसके जो सिंकोना की बार्क होती है वो किसके लिए बहुत ट्रेडिशनली यूज हो रही थी?
मलेरिया।
बिल्कुल से
मलेरिया।
इसका केमिकल स्ट्रक्चर इसका कब डिस्कवर हुआ? सिंकोना बार्क का विच ईयर एंड हु डिड इट? लगभग 1844 में एक फ्रेंच साइंटिस्ट ने किया. Then thereafter, method of synthesizing, right, that was developed, and thereafter that formula was shared with the pharmaceutical, and the pharmaceutical that made a medicine. It has a very popular name. What is the name of that medicine, sir? That is being used. बिल्कुल सही. Now, it is not the bark, natural farming जैसे हम अगर करने जा रहे हैं तो what are these steps? Number one, first question, gate number one is whether the invention that you have brought is patent eligible or not. For example, you have a plant in your hand and go to gate number one. The gatekeeper will say that, look, you cannot enter this gate. Why? Because section 3J does not allow it. It's very clear. It says plant, animals, or any part thereof, seeds, varieties, तो वो चीज तो हम कर नहीं पाएंगे. अगर हम मेथड के लिए जा रहे हैं तो एच में हिट हो जाएगा. एनी मेथड ऑफ एग्रीकल्चर और हॉर्टिकल्चर गया. Traditional knowledge, which in effect is a traditional knowledge, is not patentable, but an invention based on traditional knowledge is patentable. अब based on क्या है? जैसे हम लोग अगर बात करें तो जितने लोग आप लोगों में से ज्यादातर लोग सब लोग साइंटिस्ट होंगे. मैं साइंटिस्ट नहीं. Sir, anyone who can explain the difference between a scientist and inventor, though it is not necessary that only a scientist can be an inventor, but generally inventors are scientists. Anyone who can explain the difference between a scientist and an inventor?
Scientist and inventor can be anybody, not necessarily with a degree.
So what is the difference between scientist and inventor? मैं रिक्वेस्ट सिर्फ ये करूंगा.
हमें दो चल रही है ना साथ, एक की तो ऑलरेडी चल रहा है, वो थी ना आज.
नहीं, लू चल रही है तो इस लेक्चर से क्या लेने देना है लू का?
Sir, in fact, on this platform, many members have been connected on online. So there is a disturbance from their side.
अच्छा, उन लोगों को ये भी बता दीजिए कि सब लाइव स्ट्रीम हो रहा है. हाँ, सब लोग देख रहे हैं कौन क्या कर रहा है.
तो अभी म्यूट किया उनको.
अच्छा. नहीं तो वो पेटेंट लॉ में लू चलने लगी. फिर दूसरे गेट पे जब आप जाएंगे तो अगर आपने कह दिया कि नहीं भाई प्लांट नहीं है, ये नहीं है, तो पहले तो आपको वही गेट वाला रोक देगा. साहब, पेड़ लेके आप अंदर नहीं जा सकते, जानवर लेके आप अंदर नहीं जा सकते, पेड़ का कोई हिस्सा नहीं लेके जा सकते, या जानवर का कोई हिस्सा नहीं लेके जा सकते. और अगर आपने क्या इसमें क्या यूज किया है, अगर वो एसेंशियल बायोलॉजिकल प्रोसेस है. Sir, anyone who can tell, I was asking, I wanted to know the difference between a scientist and an inventor. पहला तो यह कि it is not necessary that a scientist must also be an inventor, or inventors are only scientists. Anyone can be an inventor, but generally scientists are inventors. But what is the difference that distinguishes between an inventor and a scientist?
Systematic investigation. This is systematic investigation and discovery of particular,
ये सर साइंटिस्ट का काम है दोनों।
Yes sir, systematic investigation.
ये भी साइंटिस्ट का है, डिस्कवरी भी साइंटिस्ट का है। इन्वेंशन की बात हो रही है। डिस्कवरी इज समथिंग विच इज ऑलरेडी देयर एंड समबडी, फॉर एग्जांपल, precise location of BRCA1 and BRCA2 at chromosome 13 and 17 respectively is a discovery. आप लोगों ने अगर BRCA1 BRCA2 जीन्स के बारे में पढ़ा होगा, it's there in the nature, and somebody, the scientist, discovered the precise location of these two genes known as BRCA1 and BRCA2. BRCA1 at chromosome 17 and BRCA2 as chromosome 30, and that where they are located and what is the sequence of that particular gene. So this is discovery, and this is the work of a scientist, not that of an inventor.
जैसे एज कॉन्ट्रास्ट माइक्रोस्कोपी है, उसने फ्रिट्ज जेर्निके ने उसे इन्वेंट किया है सर। इन्वेंट मींस मतलब असेंबल करके उसने खुद बनाया है, इजाद किया है, उसे बोलेंगे इन्वेंट।
आपने बहुत सही बात बताई, बनाया, मेड। क्या बनाया? क्या हर कुछ जो बनाया जाता है वो इन्वेंशन होते? जवाब है नहीं। उसमें नंबर 1 नयापन, नया क्या है उसमें, नॉन ऑब्वियस क्या है।
लाइक कंपाउंड माइक्रोस्कोप भी सर वो भी इन्वेंट किया गया है, लेकिन जैसे हम लोग जो भी हैं, जैसे साइंटिस्ट हैं, वो ऑलरेडी नेचर में एग्जिस्ट है। उस प्रोसेस को हम रिसर्च क्वेश्चन बनाते हैं, हाइपोथेसिस डिजाइन करते हैं एंड वी प्रूव इट। वी डिस्कवर ऑलरेडी जो प्रोसेस है उसको हम एग्जिस्टिंग है, उसको हम लोग ऐसा बताते हैं।
सर साइंटिस्ट जनरली नॉलेज पूल या जो है उसको डेवलप करते हैं बेसिक रिसर्च के थ्रू, और वो जो नॉलेज पूल होगा उसको अप्लाइड एस्पेक्ट में ले जाते हैं इन्वेंटर सर।
तो सबसे पहली बात तो क्या है ना कि इन्वेंटर होने के लिए टेक्नोलॉजिस्ट होना जरूरी है। जैसे साइंटिस्ट, साइंस एंड टेक्नोलॉजी पे हम लोग अगर डिस्टिंग्विश करें, देन नॉट एवरी टेक्नोलॉजी, a technologist who is above average intelligence, who has the ability to make something new, something non-obvious, and something useful, capable of industrial application. अच्छा, 1 घंटे के समय में जैसे मैं बताऊं, अगर नॉवेल्टी मैं बोलने लगूं कि व्हाट इज नॉवेल्टी, दैट इज गोइंग टू टेक टाइम। लेकिन एक चीज क्या है कि नॉवेल्टी, अगर हमारा कोई एक पेपर किसी ने पब्लिश किया, एंड देखिए साइंटिस्ट में और टेक्नोलॉजिस्ट में, एकेडमिक्स में और पेटेंट में एक जो पैराडॉक्स है, इन पेटेंट लॉ द मंत्र इज पब्लिश एंड पेरिश। एकेडमिक्स में मंत्र है साइंटिस्ट के लिए पब्लिश और पेरिश। पब्लिश नहीं करेंगे तो प्रमोशन नहीं होगा, ये नहीं होगा, वो नहीं होगा। वहां पे पब्लिश किया, किसी और ने उससे वो कर लिया, वो हो जाएगी प्रॉब्लम। तो जो आपने सवाल पूछा था उसमें जब तक स्पेसिफिक ना बताया जाए कि साहब ये चीज इन्वेंट की गई, तो नंबर 1 क्या इन्वेंट किया गया? आपने प्रोडक्ट इन्वेंट किया, प्रोसेस इन्वेंट किया। अगर प्रोसेस की बात आप करेंगे, 3H हिट कर देगा, कह देगा बिल्कुल आप आ ही नहीं सकते, क्योंकि ये एग्रीकल्चर या हॉर्टिकल्चर से ये रिलेटेड है। प्रोडक्ट आप लेके आ रहे हैं तो क्या प्रोडक्ट लेके आ रहे हैं? अगर वो प्लांट है, अच्छा प्लांट की जो डेफिनेशन है यहाँ पे वो सिर्फ उसके सेंस में नहीं है, उसमें जितने भी है आपके हर्ब, श्रब, ट्री, ये सब जेनेरिक यूज में उसका वो हुआ है कि हम लोग बिल्कुल ये नहीं कि ये प्लांट है और ये प्लांट नहीं है। दैट डिस्टिंक्शन इज नॉट मेड इन पेटेंट लॉ। सर क्या कुछ हद तक मैं आपके सवाल का जवाब दे पाया या नहीं दे पाया?
Yes sir.
और कोई सवाल किसी का है? क्योंकि हम लोगों का टाइम भी खत्म होने वाला है और आप लोगों का भी पता नहीं। मैं तो आई कैन कंटिन्यू फॉर सम मोर टाइम, लेकिन अगर आप लोग विलिंग हो तो। और मैं ये चाहूंगा कि आप लोग के जो सवाल हो वो पूछ ले, और ये स्लाइड मेरे पीपीटी जो है इसको मिनिमाइज कर दे। कुछ सवाल हो तो आप लोगों से मैं जनरल डिस्कशन कर लूं इस पर।
सर मैं एक क्वेश्चन पूछ सकती हूँ?
बिल्कुल, मुझे बहुत खुशी हो गई उस सवाल का जवाब देने।
इन्वेंशन और डिस्कवरी में क्या डिफरेंस है?
डिस्कवरी देखिए नेचर में होती है, वो कोई सबसे पहले किसी चीज को ढूंढना और किसी चीज को बनाना। जैसे आपसे मैं पूछूं, वॉज फायर डिस्कवर्ड और फायर इन्वेंटेड? वॉज व्हील इन्वेंटेड और वॉज व्हील डिस्कवर्ड? दो सवाल का सोचिए, अब जवाब दीजिए। फायर की हिस्ट्री क्या है? फायर हमने इन्वेंट किया है कि डिस्कवर किया है? और वो भी सिरिंडिपिटस रही हो। देखिए, बाय चांस बाय एक्सीडेंट किसी ने नोटिस कर लिया हो, दो पत्थर टकराए और उससे वो बोले क्या हो गया, फिर उसका तरीका उसने ढूंढ लिया। लेकिन जब पहिया बनाना हुआ तो उसके लिए क्या है, ह्यूमन एफर्ट लगा। इन्वेंशन in one sense is an abbreviated form of human intervention. जब हम डिस्कवर करते हैं कोई चीज, तो कोई चीज किसी को नहीं मालूम थी, हमने सबसे पहले, जैसे अमेरिका वाज डिस्कवर्ड, इट वाज नॉट इन्वेंटेड, इट वाज नॉट इन्वेंटेड, तो वो चीज थी वहां पे। मैंने ब्रेका 1 ब्रेका 2 का एग्जाम्पल दिया था कि वो तो डिस्कवर किया गया कि इस क्रोमोसोम पे ब्रेका 1 लोकेटेड है, इस क्रोमोसोम पे ब्रेका 2, तो नेचर में है, नेचुरली अकरिंग है। अच्छा, नेचर में जितने मान लीजिए माइक्रो ऑर्गेनिज्म है, क्या हम लोगों ने सबकी कैटलॉगिंग कर ली है? या ह्यूमन जीनोम प्रोजेक्ट कंप्लीट हो गया है, पूरी जीन मैपिंग ह्यूमन बॉडी की कंप्लीट हो गई है, कुछ नहीं बचा? तो जब हम कोई चीज ढूंढ के लाते हैं, हमें या चलते चलते मिल जाए और तो नई चीज हो बिल्कुल। इन्वेंशन में आपको हमको क्या करना होता है, एक तो इन्वेंशन का जो थ्रेशोल्ड है वो ग्लोबल होता है। जैसे वन कैन नॉट री इन्वेंट दी व्हील नाउ, लेकिन पर्पज ऑफ पेटेंट लॉ के लिए व्हील का आज भी इन्वेंशन हो रहा है। आप देखिए कितनी तरह के टायर आते हैं, जो हाई एंड कार्स आ रही हैं 12 करोड़ 15 करोड़ की, उनमें जो टायर यूज हो रहे हैं, अगर उन पे मिसाइल से भी अटैक हो जाए तो भी वो 100 किलोमीटर चलने का दावा करते हैं, व्हाट दे क्लेम, लेकिन वो उनकी कीमत ज्यादा है। पहले हम लोगों ने ट्यूबलेस टायर नहीं सुना था अपने बचपन में, मैंने नहीं सुना था, अब ट्यूबलेस टायर आने लगे, उसमें बड़ी क्वालिटी आने लगी। बल्ब का इन्वेंशन हुआ, अब पता चला, फिर उसके बाद थोड़े दिन बाद आया साहब वो CFL आ गया, CFL के बाद अब LED आ गया, LED के बाद अब सौर आएगा। तो ये क्या होता है, इन्वेंशन आर जनरली एवोल्यूशनरी और इंक्रीमेंटल, स्टेप बाय स्टेप हम जोड़ते जाते हैं उसमें कुछ। some of the inventions may be revolutionary also, some of the inventions may be exponential also. जैसे अभी हम लोग चैट GPT 5 की बात कर रहे हैं। चैट GPT 5 क्या कर सकता है कि इट कैन मिमिक माई राइटिंग स्टाइल। I will read my some writing and will form an impression as if it is written by me. अब चैट GPT 6, that is one platform or one app of generative AI. There are other players in the market. So what they are doing? They are mostly in the business of invention. Maybe that they are discovering something and building on that. Silica was discovered, right? Semiconductor integrated circuit was invented. Germanium was discovered. Semiconductor integrated circuit was invented. जैसे Robert Noyce, Jack Kilby working in different labs. So invention number 1 must be patentable in the patent law sense. It must not be excluded by the Patents Act. Number 2, it must be new. Number 3, it must involve an inventive step. Number 4, it must be capable of industrial application. फिर 4 गेट जो है प्रोसीजरल लॉ के, रिटन डिस्क्रिप्शन होगा, इनेबलमेंट, बेस्ट मोड, क्लेम्स, ये 8 गेट्स हैं। और टाइम हम लोगों के पास थोड़ा सा कम है कि हम लोग उसकी डिटेल में जा सके। पर्पस सिर्फ इतना सा था कि एग्रीकल्चर की फील्ड में कौन सी ऐसी इन्वेंशंस है जिसपे कि हमको काम करना चाहिए, so that we can come in the mainstream. I hope that to an extent I have been able to explain the distinction between discovery and invention. अच्छा, मेरे ख्याल से अब लोग छोड़ छोड़ के जा भी रहे हैं साहब, तो हम लोग का टाइम खत्म हो गया लग रहा है।
इन्वेंशन ऑफ माइक्रोब लिखा है आपने स्लाइड में, तो इज इट डिस्कवरी और इन्वेंशन?
हाँ, माइक्रोब्स इन्वेंट होती है ना।
डिस्कवर होगा, इन्वेंट होगा
भाई अभी देखिए, इन्वेंशन ऑफ माइक्रो ऑर्गेनिज्म आनंद चक्रवर्ती ने किया था ना, एक इन्वेंशन माइक्रो ऑर्गेनिज्म का, जिसपे डायमंड वर्सेस चक्रवर्ती का एक केस है, आप पढ़ लीजिएगा, यूएस सुप्रीम कोर्ट का।
Yes. But discovery of microorganism, that is not patentable.
100%.
You need to say that.
Anything, sir, anything occurring in the nature, present in the nature, right, found in the nature, natural phenomena, laws of nature, abstract ideas, not patentable at all. जैसे Einstein could not have patented his formula of E is equal to mc square. Archimedes' Eureka moment, not patentable. Newton's laws, not patentable. What are patentable? Product or process. Certain products are excluded from the patentability. Certain processes are also excluded from the patentability. तो एक चीज जो है, anything found in the nature, anything found in the nature is not patentable. Naturally occurring, not patentable. Natural phenomena, not patentable. Laws of nature, not patentable. Abstract ideas, not patentable. Simple.
So it means the Anand Chakravarti's case, the bacteria he has discovered, later on then he has also demonstrated the ability to eating of the oil eating bacteria as a potential. That's why he could able to patent. You mean to say that?
He didn't say that he discovered. He claimed that he invented, and he was successful in maintaining that he invented it. A microorganism that can eat oil. आपने वो बैक्टीरिया डाल दिया, वो तेल पी गए। अब तेल बहते हैं जहां पे, आप वो तेल ही पिएंगे, पानी नहीं पिएंगे।
But that bacteria was already present in nature.
But nobody has shown.
नहीं, अगर सर देखिए, अगर वो नेचर में प्रेजेंट है, उसको जब कोर्ट में गया था तो लोगों को बताना चाहिए था कि साहब ये तो नेचर में पहले से ही था। देखिए, कोर्ट में एक केस गया, उसमें सामने वाला कह रहा है मैंने इसको बनाया, उस वहां पे कोर्ट में कोई एविडेंस नहीं जा रहा है बताने के लिए कि साहब ये तो पहले से मौजूद है, तो वो क्या होगा, वो जीत जाएगा। और वो हुआ, क्योंकि देखिए मेरा साइंस, मेरा टेक्नोलॉजी एरिया नहीं, मुझे नहीं मालूम वो माइक्रो ऑर्गेनिज्म एग्जिस्ट करता था कि नहीं करता था, लेकिन जो उसने क्लेम किया, उस क्लेम को कोई कंटेस्ट नहीं कर पाया, रिफ्यूट नहीं कर पाया, और इसमें बहुत बड़ा स्टेक था, बिलियंस ऑफ डॉलर्स का स्टेक था। तो लोगों को अगर ऐसा रहता, मेरा अपना मानना है कि अगर कोई ऐसा माइक्रो ऑर्गेनिज्म नेचर में एग्जिस्ट करता होता उस वक्त, तो लोग जरूर गए होते, क्योंकि इट वाज क्वेश्चन ऑफ मनी, पैसे का सवाल था। ऐसा नहीं था कि वो लोग चुप बैठे रह जाते। तो मेरा अपना मानना है कि ऐसा नहीं था, लेकिन फिर भी द पॉसिबिलिटी ऑफ एग्जिस्टेंस ऑफ सच अ माइक्रोब कैन नॉट बी रूल्ड आउट। So thank you so much, sir. Unless you have some other question.
Genetically engineered.
Huh?
That microbe was genetically engineered. I have just seen on Wikipedia. So he had altered the sequences, genes.
देखिए, अभी जीन एडिटिंग से, अब मैं बताऊं इंडिया में सबसे बड़ी प्रॉब्लम क्या है। अब क्रिस्पर, Cas9, maybe Cas14, and if you have read the news that was published in Nature, that few weeks ago, only few weeks ago, genetically modified kidney of pig has been successfully transplanted into a human being, and after 2 weeks of hospitalization and surgery, that person is discharged and is still alive, kicking. So, if you have, you must be aware of cDNA, right? That when we make cDNA from naturally occurring DNA, right? For example, erythropoietin, EPO, is naturally occurring substance, right? It is in short supply. Somebody develops a method of making synthetic cDNA of that, complementary DNA, right? That is man-made, human-made. Copy of what is happening in there, but it can be made in a laboratory. जैसे imagine करिए कि कल को हार्ट बनने लगे लेबोरेटरी में, दिल, ब्लड ग्रुप जैसा चाहिए, जो प्लाज्मा चाहिए, सब लैब में मिल रहा है या शॉपिंग मॉल में मिल रहा है. आप जाएं, कहें कि साहब हमको ये चाहिए स्पेसिफिकेशन, आप उसको जाएं, अपने बैग में रखें, उठा के लेके आए. जैसी आंख चाहिए, जैसी नाक चाहिए, जैसा दिल चाहिए, जैसा फेफड़ा चाहिए, जो चाहे ट्रांसप्लांट करवाना हो. तो जो मेडिकल साइंस में अभी जो डोनेशन की प्रॉब्लम चल रही है, अभी एक आया कि साहब स्पाउस को अपने हस्बैंड से पूछने की जरूरत नहीं है अगर ऑर्गन डोनेट करना है. तो एक हाई कोर्ट ने कहा कि वाइफ को हस्बैंड से पूछने की जरूरत नहीं है, वो उसकी अपनी ऑटोनॉमी है. बट दैट इज द डिसीजन ऑफ वन हाई कोर्ट. अगर वो ऐसा होने लगे और फिर ये हो जाए कि जितनी इम्प्योरिटीज हैं वो सब तो निकाल दी जाएंगी जीन एडिटिंग से. सो जीन एडिटिंग इज कमिंग इन अ बिग वे. Where do we stand as scientific community, as a country, in this area is an open question, right? My approach is that if we are late in catching up with the technology, we will always remain a dependent country, dependent on the knowledge and technology produced by other countries. So we have to take lead at least in some area. Should we go for patent for that or not is a different story at all. But what is the status of use of CRISPR, for example, in your lab or in your institution? Anybody specializing in the use of CRISPR technology?
We are using it.
That's a very, very happy, very happy thing to note. And now, is there anyone who has done any new invention about CRISPR? Because we are user of that technology. We didn't invent it, right? We didn't invent it. We are the user. And there were two ladies, Dudna and Carpentier, right? They were working in different universities. They collaborated. They came up with this idea. They also won the Nobel in 2020. But do you know that they lost the patent? Patent went to Broad Institute. Didn't come to California or University of Vienna where they were working. So the point is that we have to build our competitive advantage in the field of technology. On this IP day, if we can take a pledge that whatever capacity that we are having, I'm a law teacher, I'm not a scientist, I'm not an inventor, but I know something about patent law, about intellectual property right. If we can build synergies, right? It is not expected of the scientists to understand and know or develop expertise in sciences. Let the scientists be inventor. Let the persons who are trained in law take care of the IP issues, and we can have that understanding. And then let's also take a pledge to contribute and create whatever we can do from our end in the nation building, because we must try to become technologically free, technologically independent. That we are a free and independent country. Question is, are we really independent, technologically speaking, or in technology? Are we free, or we are dependent on the technology produced by others? And if the case is the latter, that yes, we are not dependent on the technology produced by others, then we must be very happy. But if we are not, We are dependent on the technology produced by others. मैं कुछ समझ नहीं पाया क्या क्या कहा गया.
Somebody was speaking on from somewhere.
चलिए ठीक है कोई बात नहीं. तो और कुछ जैसे हम लोग को अपना जब तक एक चीज क्या है ना, मेरा अपना मैं एक सवाल पूछता हूँ और आप लोगों से भी पूछूंगा और उसी पे अपने इसको अनलेस कि आप कुछ और कहना चाहे कि अगर हमसे एक मल्टीपल चॉइस क्वेश्चन पूछा जाए और उसमें ये 4 ऑप्शंस दिए जाए और उसमें ये कहा जाए कि इंडिया इज और भारत इज, इंडिया दैट इज भारत, इंडिया इज और भारत इज ऑप्शन ए producer of new knowledge and new technology, option B distributor of new knowledge and new technology, option C importer and consumer of new knowledge and new technology, option D broker of new knowledge and new technology. कौन सा ऑप्शन आप लोगों का होगा बताइए. मल्टीपल चॉइस में क्या होता है, एक ही सही होता है, मोस्ट अप्रोप्रिएट. सब जगह यही सवाल जवाब मिलता है. तो ये देखिए हमने प्रॉब्लम आइडेंटिफाई कर दी, ये आइडेंटिफाई कर लिया हम कौन है एज अ कंट्री इन नॉलेज सोसाइटी, इन नॉलेज इकोनॉमी, इन टेक्नोलॉजी ड्रिवन इकोनॉमी. क्या हम वही रहेंगे या हम अपने अपने लेवल पे जो हम कर सकते हैं कि वी विल बिल्ड एन एनवायरमेंट ऑफ क्रिएटिविटी, an environment of innovation, invention in our country. कि हर लैब से कुछ इन्वेंशन तो आए से जो पाथ ब्रेकिंग हो, जो वर्ल्ड न्यूज बने. देखिए क्या है, कोई न्यूज हम ऐसा क्रिएट नहीं कर पा रहे. 21st सेंचुरी की एक इन्वेंशन बताइए जो इतने सारे इन्वेंशंस आए. लास्ट डिकेड ऑफ 20th सेंचुरी क्लोनिंग हुई, डॉली वाज क्लोन्ड. इंटरनेट आता है, सोशल मीडिया आता है, चैट जीपीटी आता है, क्रिस्पर आता है, क्लाउड कंप्यूटिंग आती है, क्वांटम कंप्यूटिंग आती है, आपकी आईओटी आता है, ब्लॉकचेन टेक्नोलॉजी आती है. किसी का बर्थ प्लेस क्या हमारी कंट्री है? तो अगर नहीं है तो हमें सोचना है कि कौन सी ऐसी चीज पैदा होगी जो हम बनाएंगे जो कि पूरी दुनिया को चेंज कर देगी. और वो सिर्फ हम लोगों को बात करने से नहीं, काम करने से भी होगा. मेरी तरफ से आप लोगों के लिए बहुत बहुत धन्यवाद और बहुत बहुत शुभकामनाएं इंटेलेक्चुअल प्रॉपर्टी दिवस की, जो इंटरनेशनल लेवल पे बनाया जा रहा है. हम एक दूसरे को मुबारकबाद दें कि हम इसमें इस प्रोसेस में शामिल हैं कि और क्रिएटिविटी को आपस में एक दूसरे को मुबारकबाद दें कि भाई हम अगले साल जब अगर मिले तो ये होगा कि हाँ हम वी आर इन अ बेटर पोजीशन. और जरूरी नहीं कि एक दिन में सब कुछ हो जाएगा, धीरे धीरे वी विल बी inching towards where we are planning to do. Thank you so much. Thank you so much.
Thank you very much, sir, for your enlightening talk and really thought-provoking and very knowledgeable talk you have given to us, and all of us, we all are inspired through your talk. So thank you once again, sir. Now I would request our honorable director, sir, to just say a few remarks.
Thank you to our speaker today, Honorable Professor Ghayur Alam. And we are really delighted to listen to you and have been benefited with your talk. Entirely different from the other mode of presentations. You used the hybrid mode, but still were very interactive during the entire session. So we felt your presence here, and I would like to give a big hand to you.
Thank you, sir.
The subject where actually we lack the information and the knowledge. Particularly, sir, I would like to mention your last question, the multiple question you asked. In fact, if you see this question in the agricultural background, we are far behind in many countries. In agricultural research, whatever we are using is the methods which were given by someone else, we are simply using. Chemicals which were discovered or invented by someone else, and we are simply testing their performance in our research. So that kind of a status has been in the agriculture research. But now our organization, ICAR, very proactive to enhance the creativity and to bring the innovation in the research. And this particular day is being celebrated only for the purpose to bring the awareness. And that's why I requested all our students and the young journalists that they must attend this talk. So you will be inspired to listen. Actually, if you see the economy of other countries, the major portion is coming from the patents in the research. So that kind of status we will gain someday. So in that way, the today's talk, I will again express my gratitude to you and request you to visit sometime at Indore, and please be present here in the physical mode also. So we will have some other sessions. Thank you.
Thank you, sir. Thank you.
Thank you, sir. So then now I would request Dr. Mrinal Kuchalan to propose vote of thanks.
Before closing formally, I'd like to express my heartfelt thanks on behalf of ICAR and Indore to Mayor Alam Sahab. Sir, knowledge is power and some knowledge is property also. So it's not building roads. So I also express my heartfelt thanks also to all the participants because the gathering is very nice and it's very hi-fi talks. I'm listening to this hi-fi talks is also because very much pleasant. So for very much thankful for your presence and listening to Dr. Alam Sahab. And at the end, I also express our director sir, without his inspiration, research or motivation, we cannot do it. So we are thankful. And Alam Sahab, we are missing you for a tea party. So in future, we will be having you in our tea party. Now I invite all my participants for a tea party. Thank you.
I love to. I love to.
Thank you, sir. Thank you.
Thank you, everyone, and thank you, Director Saab. Thank you, every scientist, everyone, every participant, and through cooperation, because your area of expertise, my area expertise, if we join hand, we will be. If 1 + 1 will not be only 2, it will be more than 2 always. So we hope that we can. You should be working in your area. I should be working in my area. But we collaborate, build the synergies, will be better off. Thank you so much for giving me this opportunity. Thank you so much.
Thank you.